Good morning, everybody. I'm going to be presenting today on Chapter 6 in our Law of Higher Education book. The topic is Faculty Academic Freedom and Freedom of Expression. Now, this chapter was quite dense, as all of them are. It's a very encompassing book. Here are all the topics that our chapter covered. I didn't cover everything specifically, but I wanted to cover the things that I thought would be most relevant for us. So hopefully there's an appreciation in that, and we can delve into some of what I thought anyway were more of the important topics. I really focused on a lot of academic freedom and academic expression. I thought that was very interesting. And some of the court cases that are used as baselines when deciding these cases now. And we'll go through those three court cases that were a factor in developing sort of a balancing court case that they use. So let's get started. And faculty freedom and expression just in general, whether you're employed by a public or private institution of higher education, faculty members, are citizens and they're protected by the First Amendment from governmental censorship and other governmental actions that infringe upon freedom of speech, press, and association. Down below the picture, there's a legal version. And it says that lawyers and judges usually use academic freedom as a catch-all term to describe the legal rights and responsibilities of the teaching profession, which I think a lot of us can relate to. But I do want to focus on a few things that I think are important. And these are the four things I'm going to cover today. I'm going to talk a lot about First Amendment free expression rights and First Amendment academic freedom rights. First Amendment rights and other legal bases for academic freedom. I found some wonderful do's and don'ts, what academic freedom does and what it doesn't do. I want to share those with you. I thought they were very enlightening, which came from a tip out of the chapter. And then I want to go over the 4 court case studies, including the Pickering Connick test, which were 2 court cases that were sort of bridged together to use as a balancing mechanism to really decide a lot of the court cases that we have on academic freedom and academic speech. So where I got the information for the do's and don'ts was probably one of the most recognized and professional associations, which is the American Association of University Professors. Most of these norms appear in AAUP standards, statements, and reports. The AAUP has been around since 1915. There's been quite a tradition and quite a history in collecting these academic do's and don'ts, and I found them fascinating. So I hope, although they're just a list of things, I'm going to read through them, and hopefully if you have any questions, that's fine, we can talk about them, but hopefully we can glean or they can at least you can relate to some. I know I did. So all of us going into either administration in higher education or possibly being a faculty member, and then even as a student, you're going to find these fascinating. So let's get started. What academic freedom does do. Faculty and students can engage in intellectual debate without fear of censorship or retaliation. Faculty have the right to remain true to his or her pedagogical, philosophy, and intellectual commitments. Both faculty and students can make comparisons and contrasts between subjects taught in a course and any field of human knowledge or period of history. I think we've been doing that all along the way in our classes. It's been great to be able to speak up and feel safe. Both students and faculty have the right to express their views without fear of sanction. Both students and faculty have the right to study and do research on the topics they choose and to draw what conclusions they find consistent with their research. Can you say dissertation? Or even MBA, MPA, or master's thesis. It also lets us know that the political, religious, and philosophical beliefs of politicians, administrators, and members of the public cannot be imposed on students and faculty. So I think that's another thing that faculty needs to definitely take into consideration when they're discussing things in classes. These things are not acceptable. Faculty and students have the right to seek redress or request a hearing if they believe their rights have been violated. So you get to fight back. You know, there's a lot of places I know in corporate America that I spent for many, many years. If you were sanctioned or you got in trouble for something, you really didn't even get an opportunity to talk about it. You just pretty much got fired. It protects faculty and students from reprisals for disagreeing with administrative policies or proposals. So if you disagree with an administrative policy and you voice your opinion, you're protected. I mean, you're going to be professional, of course, but speaking out often in corporate America will get you in a lot of trouble. You could lose your job. Certainly will stop you from getting promoted. It does give faculty and students the right to challenge one another's views without penalty. So we can discuss things. We can talk, and that's what's really great about academic freedom. I think it does encourage learning. Serious charges. This one right here is my last one, and I thought it was important. Serious charges against faculty will be heard before a committee of his or her peers. It provides the right to due process. We get due process. We talked about this in both of our classes, including the assumption that the burden of proof lies within those who brought the charges. Faculty have the right to present counter evidence and confront their accusers and be assisted by an attorney if the case is serious enough. Now, let's talk about what academic freedom does not do. It doesn't mean that faculty can harass, threaten, intimidate, ridicule, or impose his or her views on the students. It does not also deny faculty the right to require students to master the course, but you have to teach. You can't intimidate. It does not grant an unqualified guarantee of lifetime employment. A lot of people in the world outside of academia hear tenure and they're just like, well, you got a job for life. It's not necessarily true. People that have tenure do get let go. And you know, if you break the rules, you're going to be in trouble. It does not protect faculty from colleague or student challenges or disagreements with their educational philosophy or practices. There are plenty of people that sometimes don't agree with how they're being taught something. It doesn't necessarily protect you from the challenges or the disagreement. It's something that people can talk about. You can briefly interrupt an invited speaker, maybe if you don't agree with them, but that might be compatible with academic freedom, but preventing someone from speaking on your campus or performing is not okay. Academic freedom does not protect a faculty member from investigations into allegations of scientific misconduct. Those are probably at larger universities where there's an awful lot of research going on, although it could happen at any university. The violations of sound university policies, it's just not accepted, nor from appropriate penalties, should reach charges be sustained in a hearing of record before the elected faculty body. A couple more. It does not protect faculty members from non-university penalties if they break the law. So if you're breaking the law, you're going to get in trouble. It does not give students or faculty the right to ignore college university regulations, though it does give faculty and students the right to criticize regulations if they believe they're unfair. So you do get an opportunity to speak up about things, but you can't ignore them. You can't just say, I'm not doing it. Does not protect students or faculty from disciplinary action or sanctions for professional misconduct. Those sanctions require clear proof established through due process. Sounds very fair to me. Academic freedom does not protect a faculty member from various sanctions, for example, denial of merit raises, denial of sabbatical requests, and the loss of desirable teaching and committee assignments. Also, it does not protect a faculty member who repeatedly skips classes or refuses to teach the class or subject matter assigned. So what I'm going to do now is I'm going to talk a little bit about the Pickering-Connick test. And this is so fascinating to me. I found that the Pickering-Connick test refers to a long-standing test in the First Amendment law, and it's used by courts everywhere. I mean, it's all through our Chapter 6 to determine whether a public employer violated an employee's free expression rights. And it's taken from two public employee free speech decisions from the US Supreme Court, Pickering versus the Board of Education in 1968, and then Connick versus Myers in 1983. I'm going to talk about both of those court cases, but in 2006, Ceballos and Garcetti came into play, and now it's actually called the Pickering-Connick-Ceballos. So, but I'll get to that as we go on. Let's talk a little bit about this and how it evolved. I thought this was important, although we're talking about Perry and Sitterman. It's another US Supreme Court case. But when faculty members at public institutions assert First Amendment free speech claims, as done in Perry versus Sitterman, the US Supreme Court held that a non-renewed faculty member's lack of contractual or tenure right to employment is immaterial to his free speech claim, and that regardless of the teacher's contractual or other claim to a job, government cannot deny a person to a benefit because of his constitutionally protected speech associations. These claims are usually subject to a line in the US Supreme Court cases applicable to all public employees, which is called the Pickering-Connick line, which is also referred to as test. The test takes its name, again, from two public employee free speech decisions in the US Supreme Court, which are at the bottom here, Pickering versus Board of Education and Connick versus Meyer. In 1983, the Supreme Court decided Connick versus Myers, another important public free speech case, today be the test that courts across the country apply in free speech disputes, which again is called Pickering-Connick test. However, in Garcetti versus Ceballos in 2006, the Supreme Court ruled that public employees have no first right amendment protection for speech made pursuant to their official job duties. This decision imposed an initial hurdle in public employee free speech cases for employee plaintiffs, who must show that they spoke as citizens rather than pursuant to their official job duties. And I'm going to get more into that too, but the Supreme Court in Garcetti versus Ceballos ruled that public employees do not have a first right amendment protection for speech issued as part of their official duties. So let's move on to the first case in 1968, Pickering versus the Board of Education. The case began when a school board officials in Illinois terminated a science teacher, Marvin Pickering, for writing a letter to the local newspaper about how the board was allocating funds. Pickering contested his termination in a state court, alleging a violation of his First Amendment right of free speech. School board officials countered that with a letter that was detrimental to the interest of the schools. The trial court ruled in favor of the school board. The Illinois Supreme Court affirmed the trial by a 3-2 vote. Pickering then appealed to the US Supreme Court, which was reversed in an 8-1 decision. The teacher terminated for criticizing school board in letter to newspaper. Pickering believed that the school board spent too much money on athletics and not enough on academics. He wrote, "To sod football fields on borrowed money and then not to pay your teachers is just putting the cart before the horse." The US Supreme Court determined that Pickering's letter had addressed a matter of legitimate public concern, thus implicating his free speech rights as a citizen. The court then balanced the teacher's free speech interests against the state's interest as employer in maintaining an efficient educational system. The court found that Pickering had no working relationship with the Board of Education, that his letter had no detrimental effect on the school, and that his performance as a teacher was not, affected. So, Supreme Court ruled in favor of the teacher. Justice Thurgood Marshall rejected the notion that public employees must relinquish their constitutional rights on accepting governmental employment. He wrote, the problem in any case is to arrive at a balance between the interests of the teacher as a citizen in commenting upon matters of public concern and the interest of the state as an employer in really promoting the efficiency of the public services it performs through its employers. So, Pickering versus Board of Education. Next, I want to talk about Connick, as in Pickering Connick. Connick versus Myers. The Supreme Court clarified the level of First Amendment protection for public employees in the workplace by explaining how courts balance the employee's right to speak on matters of public importance against an employer's interest in a disruptive, free workplace. Sheila Myers, an assistant district attorney in New Orleans, had objected to being transferred to another section of the office. And after receiving the notice of the transfer, she prepared and distributed a questionnaire to the office staff that raised, really partially, issues about whether their office was poorly run or not. Harry Connick Sr., which, yes, is Harry Connick Jr.'s dad, the famous musician, he was a district attorney in New Orleans, and Myers' supervisor terminated her for refusing to transfer and for undermining his authority by sending out that questionnaire. Myers challenged the dismissal, reasoning that she was fired because she had expressed her opinion on how Connick ran the office and that such termination violated her First Amendment political speech rights. Court said the dismissal didn't violate First Amendment rights. In a 5-4 vote, the divided Supreme Court held Myers' dismissal to be constitutional. In the majority opinion of the court, Justice Byron R. White stated that the court's ruling in Pickering versus the Board of Education, he used that as a benchmark to say it's not at all like Pickering versus Board of Education, and that the court must balance the First Amendment right of government employees to comment upon matters of public concern versus the interest of government to provide its services efficiently. In applying the Pickering test to the New Orleans case, White found that Myers in general was not speaking about matters of public concern because in the main, her questionnaire focused on internal office workings. This is something to really listen to here because we often get caught up in this. White determined, however, that at least one question concerning whether Connick forced office staff to perform political campaign work should be considered in public concern. Applying the balancing prong of the Pickering test, which you will hear this a lot, it's used in almost every court case regarding free speech. White asserted that Myers' questionnaire had the potential to hinder the efficient operations of the district attorney's office by questioning Connick's authority. In addition, because Myers circulated the survey as a reaction to receiving an unfavorable assignment, White found that Connick had legitimate reasons to fire her. So, did the public employee speak on matters of public concern? This test has 2 parts. The threshold part asks whether an employee, a public employee, spoke on a matter of public concern defined as a similar or larger societal significance of importance. If a public employee was disciplined for expression that is characterized as more of a private grievance, well, then the employer prevails. However, if a public employee spoke on a matter of public concern, then the court proceeds to the second part of the test called the balancing prong. Under this prong, the court must balance the employee's right to free speech against the employer's interest in an efficient, disruptive-free workplace. I think that's why you saw the affirmative take on firing Myers. She really spoke out against the office there. As I mentioned earlier, the Supreme Court developed this test in Pickering, a case involving a public high school teacher, Marvin Pickering, who was terminated after writing a letter to the editor of a local newspaper that he highly criticized the school district officials, but not people he worked with on a day-to-day basis. The Supreme Court reasoned that Pickering spoke on a matter of public concern, whether the school spent too much money on athletics and not enough on academics. The court then held that Pickering's right to free speech outweighed the school board's interest in a disruptive free workplace, largely because Pickering did not criticize people that he worked with daily, such as fellow teachers or his principal. So the balancing test weighs free speech against disruptive workplace. In Connick, New Orleans District Attorney Harry Connick Sr. fired Assistant District Attorney Sheila Myers after learning that Myers distributed this questionnaire to fellow employees, questioning various policies of the district attorney's office. Myers sued, alleging a violation of her free speech rights. The court applied the Pickering-Connick test, finding that most of the questions on the questionnaire were close to a private grievance than matters of public concern. However, the court found that one question, whether employees felt pressured to support political candidates backed by the district attorney, that touched on a matter of public concern. The court then balanced Myers' free speech rights against the district attorney's interest in an efficient, disruptive-free workplace. Like I said, the court struck the balance in favor of the DA Connick, crediting testimony from another district attorney that Myers' questionnaire caused a mini insurrection in the office. Now, for decades, the Connick-Pickering test has served as a guidepost for the public employee. First Amendment free speech claims galore. Then along comes Garcetti versus Ceballos in 2006. The court introduced a new threshold inquiry by holding that when public employees make statements pursuant to their official job duties, they have no First Amendment protections. So let's talk a little bit about Garcetti versus Ceballos, 2006. The Supreme Court ruled that public employees do not have First Amendment protection. I said this free speech issue as part of their official duties. Good to hear again now. California prosecutor Richard Ceballos alleged that his employer had retaliated against him after he criticized the handling of a search warrant affidavit that he believed contained untruthful information. Ceballos claimed that the transfer to a less desirable position and an office location, a less desirable office location, were a direct result of his critical speech. Ceballos claimed that the transfer to a less desirable position and office located were a direct result of his critical speech in a memo, his testimony at a suppression hearing, and a public speech he delivered at a conference. Now, the court ruled First Amendment does not apply to public employee speech analysis of the Garcetti and Ceballos case in examining the contradiction between employee speech and citizen speech. It becomes critical first step in deciding whether the employee's speech is protected. If the employee is speaking as an employee, as defined by the court, the speech is not protected. One need never reach the question of whether the employee was speaking on a matter of public concern. The federal district court ruled that Ceballos had no First Amendment claim for speech delivered in the memo prepared as part of the routine for job duties. The three-judge panel of the Ninth Circuit Court of Appeals reversed the Ceballos and Garcetti that they had approved in 2004 to determine that Ceballos' memo concerning lack of veracity in law enforcement officials constituted speech on a matter of public concern within the meaning of Pickering versus Board of Education, using it as a benchmark, as always. The appeals court concluded that Ceballos' free speech rights trumped the district attorney's efficiency interests. So the district attorney appealed the Supreme Court, which reversed the Ninth Circuit in a 5-4 vote. So writing for the majority, Justice Anthony Kennedy ruled that when public employees make statements pursuant to their official duties, the employees are not speaking as citizens for the First Amendment purposes. and the Constitution does not insulate their communications from employer discipline. So there were some dissenting opinions on this. I'll read you one that's encompassing a couple of folks. Justice John Paul Stevens, David Souter, and Stevens Breyer each wrote dissenting opinions. Stevens criticized the majority decisions as misguided and stated that the notion that there is a critical and categorical difference between speaking as a citizen and speaking in the course of one's employment is quite wrong. Souter, joined by Justices Stevens and Ruth Bader Ginsburg, reasoned that public employees retain First Amendment rights in their official work speech when the employee speaks on a matter of unusual importance and satisfies high standards of responsibility in the way he does it. Souter warned that the majority's decision may imperil academic freedom in public colleges and universities, whose teachers speak necessarily and write pursuant to official duties. So what this means is this public employee and their decision that First Amendment protection for speech issued as part of their official duties is something they don't have, could affect the outcomes of public colleges and universities. So this was very interesting, and the judges kind of fought back and forth on it, but Breyer wrote a narrower dissent in which he focused on special constitutional obligations imposed upon prosecutors who must disclose any exculpatory evidence to the defense. To Breyer, prosecutors such as Richard Ceballos need augmented First Amendment protection when they speak out regarding possible government abuse. So he's saying maybe we need to look at what he's saying, but the way it was done didn't quite work out. So in various cases, courts have questioned whether there are circumstances in which they should apply the Pickering-Connick rule or the Pickering-Connick-Garcetti rule. It's also called really a perpetual analysis of public employees. They use these three cases as really the leading benchmarks, the leading answers, if you can go that far, to free speech claims. Most importantly, at least for higher education, is the question raised out of Garcetti, whether the employee speech doctrine, an official duty test, should apply to public colleges and university professors when they engage in scholarship and teaching. Now, Ceballos was sanctioned basically for what he said. I didn't see if he got terminated or not, but he was certainly demoted and moved to a lesser desirable office. So does it affect academic freedom? Justice Kennedy, speaking for the majority in Garcetti, noted at the end of his opinion, there is some argument that expression related to academic scholarship or classroom instruction implicates additional constitutional interests that are not fully accounted for by this court's customary employee speech jurisprudence. So based on what I saw and what I read in the Garcetti case, I ask you this, and also it's the end at Breyer's comments. We need not, and for that reason do not, decide whether the analysis we conduct today would apply in the same manner to a case involving speech related to scholarship or teaching. So I'd like to get your comments on that. Anybody that would like to comment, thinking back to Garcetti when he saw a sheriff not do the right things under a warrant, under an arrest, and he said something. He created a memo. He clearly did something under a employee position, which was he was not given the First Amendment protection under that. But if we speak out as academics and we see something, we're protected, right? So I don't know. I want to hear some of your opinions on it. So I'll stop. stop sharing now and finish up. Thank you.